All right, let's proceed.
Morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, dumb children, or reading materials. Thank you.
This is case number 24-159-540. This is Credit Acceptance Corporation versus Starkees Boyd. The matter is before the court, set for a pretrial, and also set on for a motion for summary disposition. Your appearance for credit acceptance, please. Do I have Mr. Rosen?
Yes, thank you, Judge. I had to get off mute. Yes, I'm the attorney for plaintiff judge, my bar number 35222.
All right, thank you, counsel. Good morning to you. I'm looking for Starkees Boyd. If you're on the Zoom, please say something at this time.
I'm here, Judge.
All right, thank you, Ms. Boyd. Good morning to you. All right, counsel, I see that you filed a motion for summary disposition regarding this matter. Tell me where things are to the best of your knowledge at this time, sir.
Well, Judge, I filed this motion for summary disposition based on its answer, which appears to admit the allegations of the plaintiff's complaint and really has not alleged a affirmative defense that would make a genuine issue of material fact that would allow defense to continue with the case. I can also tell you, Judge, as an officer of the court, I've been checking the register of actions here, and I do not see a written answer to my motion for summary disposition by Ms. Boyd. The court knows, as previous practice, that MCR 2.116 G1 requires, it says, must file a response to a motion for summary disposition at least 7 days before the entry of the hearing. I have not received that, and therefore I asked for judgment today in the amount of the complaint, which was for automobile deficiency balance of $13,931.45. Judge, on that I rest.
All right, so Ms. Boyd, I don't see, excuse me, I don't see an answer to the complaint. I mean, to the motion that was filed as required by the rules. But what is your basis for alleging that this indebtedness should not be brought against you? Talk to me about that, man.
Can you hear me? It just said I was muted.
I hear you now.
Okay, and you said what are my reasonings?
Yeah, you didn't respond to the motion, and I saw your answer to the complaint, and it does not really raise anything by way of a defense. I did see that you put down something indicating that you were not mentally competent or something. Talk to me about what you believe to be your defense in this matter.
Well, in my defense, I had a car, and I traded it in to help my mother. That's why I'm kind of in this situation, because I was trying to help my mom out. Now, why my reason why I didn't reply to the motion, that was my incompetence. I didn't understand it to a certain point, and I could have asked. So that's why he didn't get an answer to the papers that was sent. Now, again, to my reasonings, I'm not saying I shouldn't have to pay, but that whole amount. And again, I was a co-signer.
Well, you do know that a co-signer is the same responsibility as the principal signer. It's a joint equal responsibility. They almost shouldn't even use the language of co-sign, but co-sign simply means that you're signing on that if they don't pay it, you'll pay it. And the plaintiff has the right to go after whoever they choose, either both or one party. Mr. Rosen, anything further regarding your motion, sir?
I think the court has perfected the record. A co-maker makes that co-maker party equally liable to the other co-maker party as if they were solely responsible for the contractual terms. I'm sympathetic to Ms. Boyd, but under the law of contracts, she really hasn't alleged a meritorious defense upon which relief can be granted. So I asked for judgment in the complaint, which was $13,931.45, plus statutory costs of $160 of a summons filing fee, $120.94 summons service fee, a $40 motion fee, total cost, Your Honor, of $320.94. I also asked for a statutory $20 attorney fee for a total judgment of $14,232.39, Judge, and on that I rest.
Excuse me. Excuse me, Judge.
Nobody's gonna interrupt, my case while I'm, making a determination. I'll get to your matter as I get to it.
The judge, I think she's on the case too.
All right, let me see this one. All right, so Counsel, you filed your motion as to both defendants in this matter. Is that correct, sir?
I believe that is correct, Judge. Let me look at my notice here.
Yeah, I'm looking at, I went back and looked at it. It looks like that's the case. Okay, ma'am, I thought you were on another matter. I'm going to unmute you. I believe that you are Ms. Boyd Hobson. If you are, ma'am, go ahead. Is that who you are, ma'am?
Yes, that's who I am.
All right, thank you, Ms. Hobson. I did not realize that you were here, ma'am. I don't see a written response from you regarding this motion either. Tell me what you wanted to say at this time, ma'am.
I wanted to say that I am Starkeis's mother, and she did trade her car in so that I could get transportation because my transportation had just been what's the word? I had a really bad accident, so it was total. And she was working and she was making her car notes for quite a while, and due to losing her job and needing to find other employment, that's how she basically got behind. And before she could rectify the situation, the vehicle was picked up. And I get Social Security. Right now, she's completely unemployed. She's on disability herself, and have not started receiving any type of payments yet. And I can actually say she did her best maintaining with taking care of her child, helping me take care of her elderly grandma. I have a handicapped sister as well, and we all try to live together and pool our resources. And it wasn't due to neglect. It was just due to losing a job and trying to find another one and dealing with that whole situation.
And,
And now she's on
All right, thank
Judge
you, ma'am.
Coleman, this is Starkeis Boyd. When the lawyer was speaking, my services went out, and I didn't hear nothing was said. So when I got back on, I think the last thing I heard him saying something about $10 and he rests, but I didn't hear anything he said because it kicked me out. I just want to let you know.
All right, thank you very much, ma'am. All right, I've listened to the arguments on the motion for summary disposition. Most of the summary disposition addresses the issue of whether or not there is a defense to the claim that is recognized in law. And while there are a number of issues that are raised by by both individuals who are defendants in this matter, there is not a defense that has been asserted that will be recognized in law. The plaintiff is enforcing rights under the purchase, under the contract regarding the purchase of the vehicle, and under Michigan law, where if the vehicle is not paid for and is repossessed, then the vehicle is sold, and then the deficiency balance, the plaintiff has the right to pursue that deficiency balance. And that's what's happening here. And there's no defense that's been raised to that. And I think the reason that there's no defense raised to it is because there simply isn't a defense. There are some difficult circumstances regarding the ability to pay, but those issues do not come up until there is some determination regarding the entry of a judgment. If a judgment is entered, then the parties have the right to seek a payment plan or to ask for installment payments, et cetera, et cetera. But right now, the motion that is presented indicates to the court that there is not a valid defense. I've looked at the answer. I've listened to the testimony or the statements made by the prospective defendants, and nothing that has been presented shows a defense to claim. For that reason, the motion for summary disposition in this matter will be granted, and the court will allow for entry of judgment on the granting of the motion. Obviously, the parties have indicated hardships and may want to file in an effort to get a payment plan. But at this point, the judgment will be entered because the plaintiff has the right to judgment as a matter of law under the facts and circumstances as presented. It is so ordered at this time. I do wish the parties well. Good day to you.
Thank you, Judge. On that, I will leave. I rest. I have to go to another judge.
All right, good day to you, sir. This is the case number 164 This is Wilmington Savings Fund Society versus Aaron James Ball. The matter is before the court. Settle on for a status conference. This is the first hearing in this matter. I do know that there is a answer filed. Your appearance for the plaintiff, please.
May it please the court. Good morning, Your Honor. Keith Satiroff, P42904, appearing on behalf of the plaintiff.
Thank you, Mr. Satiroff, and good morning to you. I'm looking for counsel for defendant in this matter. Your appearance, please. For defendant. I do see there is an indication that there is a lawyer present in this matter. Madam Counsel or Counsel, looks like the last name is Nasibo. Ms. Savova, Ms. Nova. All right, Counsel, have you had any opportunity to speak with counsel for the defendant?
I did. I spoke to the attorney. She was in 46th District Court and had 2 Zooms going. So she might be drawn away at the present moment, but we were able to talk and we hashed out a list of proposed dates, if I may entertain those dates with the court.
Well, what I'm going to do, and I'll shoot a date to you and let's see if that works. I'm going to open discovery in this matter and issue a scheduling order. And I will set it over on a basically a 60-day calendar. So what's going to happen is that the next action date in this matter would be June the 12th. And that would be, well, let's put it June the 16th. June the 16th at 9:30 would be the pretrial conference date. Does that date work, counsel?
I will check that date out. June. It'll be by Zoom, Your Honor?
Yes, sir.
Yes, that date's available.
All right, very well. So you're going to get both sides are going to get a scheduling order from me in the next couple of days. That scheduling order will have in it that date of June 16, 2025 at 9:30 a.m. as a pretrial. And then you just follow the scheduling order and then return to court on that next action.
Okay, so will this order is going to also allow discovery and will set dates for motions for summary and witness lists and all that, Your Honor?
Yes, it won't give you a witness list date, but it will give you a process for filing motions for summary disposition under paragraph number 6. and to the extent that paragraph number 6 of my order will benefit you during that term, then you can certainly use it. If not, when you return on June the 16th, I will evaluate the case to see where things are. And if I need to set a motion for summary disposition date at that time or other motion dates.
Okay.
So-
One last item, Your Honor. We filed a second case that happened to fall before Your Honor. It's just another loan, same parties. She filed the same kind of answer. It says it's almost identical, and she stipulated that it might be better if we consolidated them. That notice of scheduling conference is set for the 29th of April in front of Your Honor. I can give you the case number.
Yeah, go ahead with the case.
25-142015 GC.
So counsel, what I'm going to do is I'm going to issue the exact same scheduling order for both files. And we'll have both case numbers on the scheduling order, and both of those matters be set over for the 16th of June, 2025 at 9:30 a.m.
That sounds great, Your Honor. Thank you so much.
Thank you, counsel. Good day to you, sir.
Good day to you, Your Honor.
The court now calls case number 24-173-775. This is J.P. Morgan Chase Bank versus last name is Awadi. The matter is before the court, set for a status conference. The court, of course, is in receipt of an answer filed in this matter. Your appearance for J.P. Morgan, please.
Good morning, Your Honor. Trevor Stratton, P65124, appearing for plaintiff on behalf of the
Thank you, Mr. Stratton. Good morning to you. For the defendant, last name Awadi. Your appearance, please.
Good morning, Your Honor. Jennifer Palon, P80284 on behalf of defendant.
All right, thank you, Ms. Bellin. Good morning to you as well. I know that this is the first hearing of status conference. Any updates, the courts is mindful to send it over for a pretrial conference allowing for discovery in the interim. Anything that needs to be brought to my attention at this time?
I don't believe so, Your Honor. Just the scheduling order, 60 to 90 days of discovery with a pretrial at the end would be great.
And I would agree with all of that. Thank you, Your Honor.
All right, thank you to the two. All right, so I will set the matter over for the, I'll go ahead and use that 16th date at 9:45, 6/16/25 at 9:45 a.m. That date, of course, will be contained in the scheduling order that you will receive from me in the mail in the next couple of days. So I will see you at that time. The hearing will be by Zoom, and you'll get my scheduling order as I indicated in the next couple of days. Good day to both.
Thank you. Perfect. Have a wonderful day.
Thank you, Judge. You too.
Nasimova, did I say
Yes,
it
Your
correctly?
Honor. Yes, you did. I apologize. I had another Zoom hearing.
All right, and counsel for plaintiff advised the court of the same, and also informed me of a second case that had been filed, and the two of you wish that the court would consolidate them for purposes of setting dates. And so what I did is I am issuing a scheduling order in regard to both matters, and that the return date is going to be the 16th of June of 2025 at 9:30 a.m. So you'll get a scheduling order that references both matters, and both cases will come up at the same time on the 16th of June. You'll get that from me in the next couple of days.
Okay, and that's going to be via Zoom, Your Honor?
Yeah, yes, it is, counsel.
Okay, thank you. I appreciate that.
Thank you, counsel. Good day to you.
Thanks, you too. Bye.
Case number 25-159-122. This is Spinach Line Physical Therapy and Rehabilitation versus the City of Detroit. The matter is before the court. Set on for, I believe I have this set for a pretrial conference. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Attorney Ryan Moore appearing on behalf of Finish Line Physical Therapy.
Go ahead and put your P number on, Mr. Moore, please.
Absolutely, Your Honor. P83452.
All right, thank you, Councilman. Good morning to you. For the city of Detroit, your appearance at this time, please.
Good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of defendant.
Thank you, Ms. Cobbs, and good morning to you. I understand that there were 3 separate matters and the parties were coordinating discovery. Somebody go ahead and update me, perhaps where things are at this point. Mr. Moore?
Your Honor, this case also has a companion case pending in Wayne County involving the underlying claimant. In that case, the parties have recently done a number of procedural motions, including bringing in a few different parties as to the third-party claim. At this point, I just asked for an adjournment of this case as the underlying claimant's case continues to progress. I believe eventually we're going to end up doing a global facilitation, but I'll defer to Ms. Cobbs as to whether or not that would be something they'd be interested in the future. But at this time, because we're still doing discovery in the underlying claimant's case, I would just ask for an adjournment of this matter.
Ms. Cobbs?
Your Honor, I believe that Brother Counsel has appropriately set forth the procedural history, and we would ask for just a little bit more time because I do believe that that's the path we're headed in, Your Honor, for a global facilitation.
All right, very well. So I'm going to, all right, so I'll set it out for another 60 days, and then let's take a look at where things are. And at that time, I'll be in a better position to determine whether or not there needs to be a separate guidance in this file, or whether or not the other matter sufficiently provided guidance as to what should occur. So we'll take another look at it. I'll go ahead and put it on the 16th of June. My clerk has just told me the 17th of June. June 17, 2025 at 9:30 a.m. Matter set for pretrial and review at that time.
Thank you, Your Honor.
Thank you, Judge. Thank you, Your Honor.
The court calls case number 24169766. This is Coolidge Imaging LLC versus Nikita Davis. The matter is before the court, set on for a pretrial conference. It looks like there is also pending a motion for summary disposition in this matter. Your appearance for the plaintiff, please.
Good morning, Your Honor. Timothy Frost on behalf of plaintiff P40616.
Thank you, Mr. Frost, and good morning to you, sir. I am looking now for Nikita Davis. Ms. Davis, if you are on this Zoom, please say something at this time.
I'm here, Judge.
All right, thank you, Ms. Davis. I'm looking and I don't see a response to the motion for summary disposition in this matter. But let me hear from the plaintiff regarding this, and then I'll come to you, Ms. Davis. Counsel.
Oh, yes, thank you, Your Honor. This is our C10 motion for summary disposition. We've attached a written agreement signed by defendant whereby she agreed to pay the medical services which were provided, which were not covered or paid for by insurance. There's no dispute that defendant received 3 MRIs. She received the services. There's no dispute that services were not paid for by insurance or by the defendant. We served discovery requests, including requests for admissions, which defendant has also failed to answer, thereby conclusively admitting the allegations in the complaint. As the court knows, under C10, once the moving party has shown that there is no genuine issue of material fact the burden shifts to the non-moving party to come forth and present evidence showing that there is a genuine issue of material fact. We presented evidence showing that there is no such issue. Defendant has failed to come forth and present any documentary evidence showing that there is such an issue of material fact. We, as the court noted, there's been no answer filed. I would object to oral argument. Of course, oral argument is not evidence in the record, and therefore we request that the court grant our motion.
All right, thank you, Counsel. Objection is noted regarding oral argument, but let me hear from you over objection. Ms. Davis, anything you want to say at this time?
Yes, there is something I would like to say, Judge. I was referred to Parkwood Open Imaging. So as I stated to you prior, last court, I have medical background. So there should be a referral note sent over from the referred doctor to the MRI doctor. Something may have been a mishap with the communication between those two, because I'm not understanding how this facility is billing me $15,000 almost, and the referred doctor is not billing me at all. That bill is taken care of. This facility is the only place that is trying to bill me in another one, because you guys are not doing the due diligence to look over my medical history that is referred over with me prior to my appointments. So I was sent over the paperwork from the lawyer, the plaintiff's lawyer, which I did not sign, because I'm not arguing with nobody when the facts are there. They sent me over a paperwork that stated Exhibit 1. Okay, I did fill out the top and the bottom. When I got there, if I could remember, I was told, do not fill out the middle part where it states for the insurance, because that was sent over with your referral. So thank God that I have sent that paperwork was sent to me via mail recently, because I would have never known this. Where it states the insurance information, that is not my handwriting. It states that my secondary is Medicaid, and that is not true. Medicaid is my primary insurance. The referred doctor medical records even states that my primary insurance is Medicaid. So this is a mishap on Parkwood Open Imaging end. Once again, I was in an accident on a public transportation. I do not have a vehicle. I do not own auto insurance. So that is not me checking a check mark on auto insurance, because I do not own a car in Michigan. I don't even have a license. So I'm not going to break the law and cause myself to get into an accident or anything else. Secondly, they put incorrect accident date. That's not my handwriting either. It states 113. The accident date is 1/12/2023. So my question is, why didn't Open Imaging do their due diligence prior to suing me? Why did they do the extra step for their patients to go that extra mile to not cause extra stress on them, being that I am an innocent person that is injured, that's already dealing with enough? Why you guys didn't do that much? There's no argument. It's just facts. You guys did not do your job correctly. Because if the referred doctor states that my primary insurance is Medicaid, why did somebody put their handwriting? Because that's obviously not my handwriting. That is totally different if you look at the paperwork on Exhibit 1.
All right, ma'am. Thank you. Thank you, ma'am. All right, counsel, anything further? You get the last word regarding this. Here's my concern. My concern before you speak is simply that it appears that from the records that the services were performed. And if the services were performed, then the plaintiff has the right to pursue collection regarding the services that were performed. I have a signed document. The document is called patient registration. And there may be other documents that were signed, but notwithstanding if there are any documents signed, if the services were performed, then the plaintiff has the right to pursue recovery of the costs associated with performing those services. That's the challenge here. Whether someone put the wrong insurance coverage down or anything along those lines, notwithstanding, and if there is in fact insurance available at this point, then the plaintiff, strike that defendant, certainly has the right to submit any obligations to to her insurer to get this paid off. Counsel, talk to me, Mr. Frost. Anything further, sir?
We'll just say defendant has not raised a material issue at this point, Your Honor. She signed the registration, thereby adopting the statements thereon. I have nothing else at this point, Judge.
Judge, I would like to say something. That is the paperwork that I'm speaking of. The patient registration is the section that says insurance information. If that is done correctly, none of this would have started. As I stated, I come from a medical assistant background, so I understand billing and coding. I understand how to do due diligence for my patients. I will not stress.
Okay, let me stop. Everything that you're saying right now, you already told me that. I don't need to hear that twice. And I'm not being rude to you. I'm just telling you, you already said that. Here's the issue. The issue is whether or not you receive the services. That's the issue. And if you receive the services, then the next issue becomes, what, if any, defense do you have for not paying for the services that you receive? And everything that I've heard does not show that there is a genuine issue of material fact regarding the services that were performed. If there is insurance involved, then insurance, I suppose, can still be dealt regarding this matter. But the person primarily responsible for services provided is the person receiving those services. And the MRI services were performed. The request to admit document was never answered or not responded to. So those things become deemed admitted. And it sounds to me that that the defendant raises some meaningful issues about whether or not the patient services, such as making sure that forms were filled out properly and so on and so forth, whether there was a failure along those lines. Maybe there was. But the underlying issue here is, was the services performed? Were the MRI services performed? And they were. That has been admitted by the failure to respond to the request to admit, and the billing for those services that were made. The plaintiff has the right to pursue damages to collect for the cost of those services that were performed. If the defendant has an insurer that will pay those services, then she can still go to them and have them to pay for those services. But if they don't pay, then unfortunately the responsibility inheres to the patient. Insurance is just a backup. It is a system that is designed to pay where they are on the obligation or on the hook to pay based upon an insurance contract agreement. If they do not, I know you're not interrupting me. I just know that. I know that.
No, I'm actually.
So my determination is that
I'm crying. I'm not interrupting you. I'm crying.
But you shouldn't even be unmuted because I'm talking now. And I apologize for you if you're crying about this. And I know that this is a difficult thing for you and for perhaps other people that are involved. But the issue is very simple here. Although it's a hard issue, it's a very simple issue here. And that is that services were provided and the plaintiff under law has the right to collect money for the services provided. That's why I'm granting the motion for summary disposition in this matter for that simple reason. There is not a defense that's been raised to that. That is the law. That is how the law works in regard to these matters. And again, just by way of reiteration, to the extent that there is someone that is willing to indicate that they insure you in relationship to the cost of these services, you still have the right to take this information to them and point out to them that you were charged with services that were rendered and the insurance should have covered that. And if they'll cover it, then they'll cover it. If they don't cover it, then it's your responsibility. That is my determination. I'm signing the appropriate order in that regard.
Sir, to understand my insurance, you will understand why
I do wish both sides.
my insurance doesn't cover this.
And I don't know if your insurance covers it. If they don't cover it, that they don't cover it.
Okay, please let me talk to.
I already allowed you to talk, ma'am. You talked several times. I gave you several opportunities to talk.
Okay, but
That's my determination. Good day.
Thank you, Your Honor.
All right. I have I'll assign this. Now, you said this over for today or?
Yes, that was for today, for review, just review.
We'll address it later. They haven't shown up.
No,
Issue, so
they did not.
maybe I'll set another date.